Tyler, are you out here, sir?
How are you doing,
Hey, Leslie, how are you?
I'm good, how are you?
Yeah.
And we're fixing to. Good afternoon, ladies and gentlemen. The Business Utility Subcommittee is now in session. Mr. Clerk, please open the board so we can take the roll. Take the roll, Mr. Clerk.
Mr. Chairman, you have 9 members present. You have a quorum.
Thank you for that. And if you would, audience, please stand. Leader Cochran's going to lead us in a prayer and the pledge.
Dear Lord, thank you, God, for just allowing us to gather here today. Lord, we ask you, as we do the business of the people of the state of Tennessee, Lord, we ask you just for wisdom and discernment. God, please be with everyone here and just watch over and protect them. In Jesus' name we pray. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all for being here. Right off the bat, though, to get started, if we have, we'll have one witness, one opposing, and one in support of whomever that may be. If there's several witnesses that want to talk on a bill, we'll just, if you would, work that out amongst yourselves so we can decide, you can decide who it is you want to represent, the opposing side or the supporting side. We're going to try to get done today, Lord willing, so let's be quick, fast, and in a hurry. And with that, do we have any personal orders? I'm going to start here. Our research analyst, Mr. Alex, over the weekend, he came home with a baby. So he and his wife have their first child. His wife must be a trooper because he showed up to work on Monday. So really appreciate his dedication, his hard work. He's been great to work with, and congratulations. I mean, doesn't even have any bags under his eyes, so, go get it. Also, I'd like to welcome my wife and my daughter, both my daughters, Hadley Jackson, and my wife, Christy. They're here with us today. last week I was talking about that being our anniversary. She wanted to make sure I didn't make a fool of myself this week. So she come in and kind of babysit. Any other? Tyler, do you have anything to add?
Yes, sir, I do. Good afternoon, everyone. Today's words of wisdom come from the baddest man to ever walk God's green earth, Chuck Norris. The only time we fail is when we stop trying. Y'all have a great afternoon.
Thank you, Tyler, for your encouragement. As we get into our calendar day, seeing there will be no other personal orders, right off the bat, item number 5, House Resolution 149 by Representative Garrett. He's asked to take that off notice without objection. Off notice. Item number 5, item number 8, House Bill 2056 by Representative Town. He is asked to roll that to the final calendar 2. So without objection, roll to final calendar 2. Item number 13 by Representative Dixie, House Bill 2235. It has failed in the Senate, so we're going to roll that bill to final calendar 2. So without objection, roll to final calendar 2. That brings us to item number 1, House Bill 569 by Representative Farmer. We have a motion and we have a second. This bill was amended last week in committee. We voted on the amendment. So the bill that you're going to present is as amended. Is that correct?
Yes, Mr. Chairman, I have another amendment. It's untimely, and it makes an adjustment to the bill. I didn't know if you don't have it,
Chairman Vaughn.
Thank you, Mr. Chairman. Thanks for recognizing me. I'd like to move that this committee consider untimely filed amendments for the purpose of getting through this final calendar. And that's been our tradition that we don't take them anytime during the year, but once final calendar is published, in order to, so we don't just get into a do loop and wind up being here week after week. That's the way that I'd like to see us handle it.
We have a second. We have a second. All in favor of the amendment, we take the motion to take untimely filed amendments, say aye.
Aye.
Any opposed? The ayes have it. Thank you, Chairman Vaughn, for that motion. Now we can take your amendment, Chairman
and what
Farmer.
this amendment is Amendment Code 15999. And the difference between this amendment and the last one we adopted last week is that this takes the underwriters out of the equation. So it's less.
We have a motion on the amendment. And that is 15999. 15999. We have a motion and a second. All those in favor of putting this amendment on the bill, say aye. Any opposed? The ayes have it. The amendment's been put on the bill and you're recognized on the bill as amended.
And thank you, members. Just to recap what this bill does, it requires 2 or 3 things. I think it provides a level of transparency to the consumer if title companies are going to be sharing fees with other title companies, that at least the person that are paying those fees, the consumer, know that those fees are going to be shared. So it require an acknowledgement from the consumer, knowing where their money's going and when they pay it, who and who's representing who. And also it would require that the title companies have acknowledged that both of them cannot accept responsibility and liability. So it would be the buyer's side that would have that responsibility, and that way the consumer would know who's responsible if something were to happen. They can't be playing the blame game. So there we go.
You've heard the explanation by the sponsor. Do we have any questions for the sponsor? Chairman Clemens?
Thank you, Mr. Chairman. And unfortunately, I obviously haven't seen this late filed amendment, so I'm not sure exactly what the overall impact of it is. So I know we got to vote on this today, but what's the significant change? I mean, we heard testimony last week, 2 very different opinions about the same piece of legislation as it was amended last week. Is this new amendment the result of a compromise? I know that wasn't really wanted by some, but is it a result of a compromise, or does it prevent anybody from doing business the way they're doing it today, other than requiring them to be transparent about it? What's the significance of this legislation in its current form?
Representative Farmer, you recognize?
And the difference is that the previous amendment required that the underwriters acknowledge and approve that title companies are able to share fees. What we did, we took the underwriters out and added language that says that only the buyer's side who is purchasing the title insurance policy can accept responsibility, because that's where it's at. I mean, if you're the buyer, you purchase the title insurance policy for your home that you're going to be living in. So who else should be responsible for it? The seller side certainly shouldn't be. So why do we say, well, we're going to be responsible just because we've accepted some money, when the buyer's side has done all the work? They've done a title search, they've issued a title opinion, and they've accepted the money on behalf of their underwriter. So what the significance is that we took the underwriter out of the equation and handled it a different way.
Chairman Clemens? Any other questions? Seeing none, we'll be voting on sending House Bill 569 as amendment on the full committee. All those in favor vote yes. All those opposed vote red. No. Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 2 nays.
The ayes have it. Congratulations, Chairman. You're on the full.
Thank you.
Number 2 on the list is House Bill 1970 by Chairman Farmer as well. We have a motion and a second. We also have a community effort on this bill.
Correct.
I believe we've got an amendment by Leader Cochran. Can we get a motion on that amendment? We have a motion on that amendment and a second. Leader Cochran, I'm going to recognize you on the amendment.
Thank you, Mr. Chairman and members, and Chairman Farmer. Thank you. This is, there are hostile takeovers and then there's a friendly one. This has been a friendly takeover. With this is changing the purpose of this bill. What this amendment does. So last year, I'll give you the highlights, kind of the quick story. Until last year, it was the general practice that licensed surveyors prepare the surveys, and then attorneys and title companies prepare the legal descriptions for deeds that are based on those surveys. We passed a bill last year, however, that I think maybe unintentionally made it where attorneys can no longer prepare legal descriptions from surveys when the survey divides property. For probably a couple hundred years, attorneys have always been able to do that. When we took that ability from attorneys, it's created a bit of a backlog on preparing deeds. This amendment simply, where last year we made it where it was only licensed surveyors, this also adds attorneys who are licensed to practice in this state. So it just adds another profession or professions that's been doing this for many, many decades to allow them to prepare a deed.
Thank you for that description. Do we have any questions for Leader Cochran? Seeing none, we'll be voting on putting amendment 16009.
Yep, that's correct, Mr. Chairman. 016009.
Okay. We'll be voting on putting amendment 16009 on House Bill 1970. All in favor, say aye. Aye. And all those opposed, say no. The ayes have it. The bill has been amended. Chairman Farmer, you are recognized on your bill amended by Leader Cochran.
Yeah, I think Chairman Cochran, Leader Cochran done a wonderful job explaining that. I'll just stand on what he had to say.
Do we have any other questions? Seeing no questions, we'll be voting on sending House Bill 1970 on the full committee. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes and 0 nays.
Thank you, Leader Cochran and Chairman Farmer. House Bill 1970 on the full committee.
Thank you, Mr. Chairman, committee.
Number 3 on our list is House Bill 2223 by Speaker Marsh. We have a motion and we have a second. You are properly before the committee and recognized, Speaker.
And Mr. Chairman, thank you. And we do have an untimely amendment on this one that we got this morning. I'd like to go ahead and put that on because it makes the bill. It's 16010.
Okay, we have that. We have a motion on the amendment. We have a second. All those, this amendment makes the bill?
Yes, sir.
Anybody, we have any objections to putting this amendment on the bill? Seeing none, we'll be voting on putting this amendment on the bill. All those in favor say aye. Any opposed? The ayes have it. You are recognized on your bill as amended.
Thank you, Mr. Chairman. This bill as amended adds a new class description, adds a new description of items in firecracker station section of the book of the code. It's novelties and sprinkler devices. This amendment makes it permissive for local governments. The bill does not affect current local ordinances, but would allow for this new category of fireworks to be sold in retail stores if the local government passes an ordinance to allow. It helps distinguish low-risk fireworks from high-risk items by defining ground-based sparklers, spinners, and other novelty items. It creates a permit requirement from the state fire marshal for any retailer that wants to sell these newly defined products. If we pass this, it also puts a lot of our citizens to work and it increases our sales tax revenue all across the state. It balances public safety, regulatory clarity, and free market practices, ensuring Tennesseans can safely enjoy low-risk fireworks and sparkling devices year-round. With that, I'll answer any questions.
Do we have any questions currently for Speaker Marsh? Seeing none, we do have two people that are here to testify, Mr. Charles Walker and Mr. Chad Hunt. If you would, each of y'all come up here and one sit on this side and the other sit on this side, and you'll each have 3 minutes. So without objection, we'll be going out of session. We'll control your mic. You each have 3 minutes to make an opening statement, and then we'll ask questions. Mr. Hunt, you're from Union City. Welcome here today. Go ahead. We'll start with you.
Thank you for having me today.
And just introduce yourself. Yes, sir.
Chad Hunt, Crazy K Fireworks in Dyersburg. So anyway, this is a bill that has come up before, and this bill is designed primarily to only help one company, and that company is an out-of-state wholesale importer. And to his point about creating jobs, all the jobs it would create would be in Alabama. So, but anyway, what's going on right now with fireworks is there are two types of products primarily, snapping pops or trick noise makers. And currently, one company that they represent has the contract with Walmart, Dollar General, Big Lots, and a host of other companies, and they're allowed to sell snapping pops and champagne poppers in those stores. So in order for them to get more product, and I noticed they amended this thing so it wouldn't include Shelby County and Davidson County, Knox County. But initially, that's what their goal was, is to sneak this in, preempt the state law, which states that if there's 350,000 people in a county, that they're exempt from selling fireworks. And so this initially was that attempt, but now they've amended it at the last minute. Nobody even understands the amendment, but it's designed to reclassify products that are illegal to be sold in markets where they sell snapping pops and champagne poppers now. So essentially, let's take example. If you took ammunition and said, well, ammunition is not allowed to be sold in this township. Well, but we change the name from ammunition to say mobile projectile devices, then we can skirt the law that's already on the books and allow ammunition to be backdoored. So that's the kind of trickery that a bill like this would represent. You're changing the name of a product that the Consumer Product Safety Commission and the Department of Transportation recognizes. And so the risks and the liabilities that this would bring on, take for example, if one of you back home at your hometown, say your cousin owned the Dollar General store that Dollar General uses, and then some of these devices explode inside of Dollar General, and then all of a sudden the landowner has no recourse because the insurance company calls this stuff that he wanted to call sparkling devices, they're fireworks. They're 1.4 G. Matter of fact, the bill even misrepresents, it states 2 or 3 times that they are consumer fireworks, Class C consumer fireworks. The Department of Transportation calls fireworks 1.4 G.
Mr. Hunt.
And so this would go against.
Mr. Hunt, your 3 minutes is up. We'll give you time to answer questions, though. You're recognized. You have 3 minutes as well.
Thank you, Mr. Chair and members of the committee. My name is Charles Walker, and I am the Director of Compliance for American Promotional Events, also doing business as TNT Fireworks. Today, I'm in here to support this amended version of House Bill 2223. This bill is doing nothing more than simply recategorizing the consumer fireworks into 3 different categories: sparkling devices, the bigger, larger, full-sea aerial devices, and novelties. This will bring Tennessee up to industry norms, as well as many of the surrounding state laws that already permit these ground-based fountains, novelties, and sparklers to be offered throughout the state, like Georgia, Kentucky, Virginia, novelties, and North Carolina and Alabama. In the past 25 years in the state of Tennessee, our company has had many of these retailers offering a full line of consumer fireworks within their stores seasonally, displayed on their shelves with no fire or life safety instances, millions of customer contacts for, over 2 decades. We believe then, still believe now, that these non-aerial, non-explosive fountains and sparklers are safe, because safety is fundamental basis to our business and to our industry. Lastly, we just feel that this would give residents of Tennessee ultimately just more choices and opportunities for celebrating holidays, especially for this year's 4th of July, which marks the 250th anniversary of the United States. Thank you for your time, and I'll be happy to answer any questions you may have.
Do we have any questions for these witnesses? Seeing none, thank you for making the trip up. Hope you have a safe trip home. Without objection, we'll be going back into session. Speaker Marsh, you're recognized.
I'll renew my motion.
Do we have any other questions for Speaker Marsh? Seeing none, we'll be voting on sending House Bill 2223 to full committee. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 3 nays, and 1 present not voting.
House Bill 2223 goes to full.
Thank you.
Next on our list is item number 4, 1627. Representative Eldridge, you have a motion and a second, and probably before the committee. I see a couple of amendments. Do you have an amendment you'd like to put on?
We do have an amendment. I believe that drafting code is 015463.
I have that same amendment number.
All right.
Would you like to put that amendment on the bill?
Yes, sir, please.
We get a motion on the amendment? We have a motion and a second. All those in favor of putting amendment 015463, say aye. Aye. Any opposed? No? The ayes have it.
I'm sorry, Mr. Chairman, but whenever we call for a vote and said, all those in favor say aye, maybe we can do it in unison. It sounds more like a kind of a machine gun going off here. If we all just say aye at one time, we might also have to practice the next time.
Looks like we're choir.
It's been some pretty weak
Yeah,
ayes.
it has been. I'm sure everybody up here is engaged in reading the mandatory language as we're preparing for the bill. I think we put that amendment on that bill, so you're recognized.
I appreciate
Chairman
that, and I
Eldridge.
know it's late in the day, and I think we're all kind of feeling that pain. So this bill just simply seeks to enact the Military Families Licensing Recognition Act. What we're trying to do with this legislation is to help our military families that get transferred into Tennessee. If they have a spouse that holds a professional license, whether it be a teacher or something like that, health. This is to help streamline the process. It does require that the licensing authorities display on their website that it does advertise the military families that may qualify for this recognition. And the purpose of it is to speed them up and helping them getting their income restored. So that's the bill.
Do we have any questions for Representative Eldridge? Chairman Powers, you're recognized.
Question on the bill.
Question's been called on the bill. Any objections? Seeing none, we'll be voting on sending House Bill 1677 as amended on the full. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes and 0 nays.
Congratulations. On the full,
Thank
Chairman
you,
Eldridge.
Chairman and committee.
Thank you for your hard work. Number 5 has been taken off notice. Item number 6, House Bill 1760, Representative Gant. We have a motion and a second. I've got several amendments up here. No, I don't. I've got one.
Well, you got more than I got. We're going with amendment 015539.
That's the same one I have. Would you like to put that amendment on the bill?
Yes, sir.
Can we get a motion on the amendment? We have a motion and a second. You're properly for the committee. Would you like to explain the amendment or would you like to vote on it, put it on the bill? I'll give you that option.
If we could just go ahead and put it on, it makes the bill.
Without objection, we'll be voting to put amendment 015539. All in favor, say aye. Aye. All opposed, say no. The ayes have it, and we are in unison. And you are recognized on the bill as amended. Leader Gant.
That sounded like the Sunday morning choir practice.
That's what we're going for.
Mr. Chairman, I'll be brief. What this legislation is doing is mainly clarifying if you're working with a city municipality and you have a third-party inspection company that you're building a house and you're, say, for example, you start out with the electrical third-party inspection. You've got to continue that throughout the process of that house being built. You can't go back, use it one time and then go back to the city inspector. You have to finish it out with that third-party inspection company. And I yield back.
Any questions, Representative Gant? Seeing none, we'll be voting on sending House Bill 1760 on to full commerce. All those in favor, vote yes. All those opposed, vote no. The board is open. Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 0 nays.
House Bill 1760 on to full commerce.
Thank you, Chairman and Committee.
I do not see Representative Renault here, so we'll roll her to, let's say, we'll roll her to the hill of this calendar. So without objection, we'll roll to the hill. House Bill number 8 has been rolled to the final calendar 2. Item number 9, House Bill 952 by Representative Brooks. So without objection, we'll roll 2 spots. Item number 10, Representative Miller.
Thank you, Mr. Chairman.
Can we get a motion?
Mr. Committee.
Well, you have a motion and a second. You're properly before the committee. Representative Miller, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, will 1918 or 1843?
1843.
Okay, thank you for that.
I have an amendment.
Yes, that amendment is 013164.
We have a motion and a second on the amendment. Would you like to put this amendment on the bill?
Yes,
Or
sir.
would you like
Thank
to-
you.
Okay. We'll be voting on putting amendment 13164. All those in favor say aye. All those opposed say no. The ayes have it. The amendment's been put on the bill and you're recognized on the bill as amended.
Thank you, Mr. Chairman. On or after January 1st, 2027 requires a public utility to apply a discount rate to electric, water, wastewater, and natural gas service provided to customers 65 years of age or older who receive an income below certain thresholds and which provides notice to the utility through an age and income verification and notification process established by the Tennessee Public Utilities Commission. Such notice must be provided by the ratepayer annually to qualify for a discounted rate. Requires each utility to provide written notice to its customers of the rate gap for such senior citizens and for the customers. That's the nature of this bill, committee members.
You've heard the description of the bill. Do we have any questions, Representative Miller? Representative Lafferty.
Thank you, Mr. Chairman. Everybody in here is familiar with Netflix, I think. There was a big sharing of families sharing Netflix accounts so that one person actually had the account. You could use it at several houses. What's to stop someone from opening up several accounts, a senior from opening up several accounts for family members, friends at different houses so that everybody gets a discount that they may not deserve?
You're recognized.
That's a good question. I don't really have an answer for that. The
Okay.
Netflix equivalents, right?
It's
Chairman Lafferty.
that's a concern. I've got where I live, within just a few minutes drive any direction from my house, I have multiple different utility companies who probably don't talk to one another. And I could just envision that someone helps family members do something like that. And then I guess another concern that I have, and I'm sorry, you wanted to say, I'll
Yeah.
pause.
Representative Miller, you're recognized.
No, continue.
Okay, my bad.
Chairman
and-
Lafferty.
Thank you, Chairman. Another concern, and I've shared this in other committees. I appreciate the idea. I've got retired parents on fixed income. I appreciate the idea of being able to lock down things like property taxes, utility bills, and things like that. But each time we do that, my concern, and we have done it in the years that I've been here, my concern is those costs eventually are going to have to be shared by the neighbors of those folks. And I get concerned about how those folks will be impacted. Most folks will never know it. They'll never feel it. It'll just be cents on the dollar on their bills. But that money still has to go to the utility from somewhere. Just because it's frozen in one place doesn't mean that the expenses have gone away. I just wanted to share that thought with the committee. But thank you, Chairman.
Thank you, Chairman Lafferty. Representative Miller.
Thank you, Mr. Chairman. I'm just going to go through the assumptions for the bill as amended, and it may answer some of those questions. This legislation will impact public utilities, of course, under TPUC purview. TPUC currently has the authority to approve, investigate, and regulate rate increases for such investor-owned public utilities. It is assumed that all affected utilities will comply with this legislation, and any revenue generated from the sanctions of civil penalties assessed against such utilities will not be significant. And based on the information provided by TPUC, there will be no significant cost incurred by the Commission to comply with this legislation, including the establishment of an age and income verification process. So again, I'm not sure how that can be prevented. Going back to your Netflix comparison, and I'm trying to understand. You would hope that people would be honest, especially if you're looking at seniors 65 and older, just trying to, save on their high utilities.
Chairman Vaughn, you're recognized.
Thank you, Mr. Chairman. I might like this bill better if it was 63 and above. Representative Miller, one of the issues that I take with the bill, and it shows your good-hearted nature of doing something for these folks, but I think structurally you've got some problems in the way it's composed because of TPUC. TPUC only deals with investor-owned utilities. So you would be dealing with a small number of utilities throughout the state, and most of those are near border towns that they near border communities that they come across in. And so you'd have Piedmont Natural Gas, and you'd have, I think there's an American Water Company in Chattanooga. There's a very, very small number of it. It wouldn't do anything for the people who are served by MLGW or NES. And so for that, it seems like we're dealing with a really small subset of folks because the vehicle that you chose to regulate this being TPUC. And TPUC, when you folks hear about it for the first time, they utilize the term public utility, and it's really private utilities or privately owned utilities or private publicly owned utilities that they regulate. And so I think there's problems with the way that it's put together here. And that's why that's one of my problems, other than the fact that anybody would care to guess whose Netflix account Representative Lafferty is watching. But I share it. I thought the point that you made was very valid, and one, frankly, that I hadn't considered. I was more drawn to the structural issues with the TPUC usage. But that's, Mr. Chairman, that's all I had.
Thank you. Thank you, Representative Vaughn.
And
Representative Miller.
Mr. Chairman, thank you for that. It's very educational, and I'm beginning to read it. And as I read this, I'm actually carrying it for my Senate colleague, but I know this is the last meeting. So if you were able to, if you think it has merit, how would you suggest amending it if it's worth it? And if we could possibly advance it and have further conversation about it.
Chairman Vaughn.
In the waning moments of this committee during this General Assembly, that would be a very tall order, my friend. But I would think that this sounds like one that would be best suited for next year. I believe you and I will be back, and we'll see. We'll see what happens next year on this one. That's kind of the read that I'm getting for it being at this point in time.
Thank you for that.
Next on my list is Chairman Boyd, former Chairman Boyd, excuse me.
Thank you, Mr. Chairman. This is a noble idea and worthy of some further discussion, as Chairman Vaughn said. And so I was going to say, if you want to roll it to next year, if not, there's no time like the summer to study these things. And I'd be happy to make that motion, or do you want to roll it?
I would appreciate your motion.
Okay.
Let's go with that.
Mr. Chairman, July summer study, please.
Okay. We have a motion for summer study. You have a second?
Second.
We have a second. All those in favor of summer study, say aye. Aye. The ayes have it. Is there anybody or no? Okay, the ayes have it. House Bill 1843, summer study.
Thank you, Mr. Chairman.
Thank
members
you,
of the committee.
Representative Miller. Number 11 on the list to get you out of here. House Bill 1918. We have a motion. We have a motion. Have a second. All right. You're properly before the committee, Representative Miller.
Thank you, Mr. Chairman, members of the committee. I tell you, Mr. Chairman, this particular bill, when I decided to accept it, I looked at the nature of it. The first thing that jumped out at me was immigration, the almost boogeyman word of this session that's going on. Some of you are going to be a little scary about it. You're going to be probably a little upset about it, but it's really simple, and it's a common sense piece of legislation. But what it does, it enacts the Tennessee Private Workplace Due Process and Warrant Protection Act. It establishes various areas, premises, and instances in which immigration enforcement activities are prohibited without a judicial warrant. Establishes various offenses against use of state or local agencies' resources for use in immigration enforcement activities in the private workplace. And that's all that this bill does.
We have any questions? You heard the explanation of the bill. Do you have any question of the sponsor? Seeing none, we'll be voting on sending House Bill 1918 on the full committee. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 2 ayes and 8 nays.
House Bill 1918 fails.
Thank you, Mr. Chair.
Thank you.
Members.
Next on our list is item number 9 by Representative Brooks, House Bill 952. We have a motion and a second. You are properly before the committee and recognized, Representative Brooks.
Thank you. Thank you, Mr. Chairman.
I have 2 amendments. Are you interested in putting either one of those on?
Just one of them, 015373.
Okay. We have a motion and a second on the amendment. I'm assuming you would like to put that amendment on the bill because that makes the bill?
Yes, sir.
Okay, we'll be voting on putting amendment 015373. All in favor say aye. Aye. All opposed say no. The ayes have it. The amendment is on the bill and you're recognized on the bill as amended.
Thank you, Mr. Chairman. This bill would establish a small business growth and impairment fund, which would be housed in the general fund. Small business growth and impairment fund will be composed of funds appropriated by the General Assembly and gifts, grants, and other donations received by the Department of Economic and Community Development for the funds. These grants will be used by the ECD to facilitate economic development activities for small businesses in underdeserved areas or in a manner that directly impact these businesses. This bill also will give business tax credits for small businesses hiring local and providing workforce training. With that, Mr. Chairman, I would ask for a favorable vote.
Do we have any questions, Representative Brooks? Representative Lafferty, you're recognized.
Mr. Chairman, I'd make a motion that we take this up as a summer study.
We have a motion and a second. Take this up as a summer study. All those in favor say aye. Any opposed? The ayes have it. If you or no one want to be recognized by the clerk, please let him know. Thank you, Representative Brooks, but good luck this summer. Item number 12, House Bill 2169, Representative Powell. We have a motion and a second on the bill. You are recognized.
Thank you, Mr. Chairman. What this bill does is, as most of you know, very familiar with, on January 25th, 2027, we had a very significant ice storm in not just here in Nashville, but in the entire state, a large part of the state. And a lot of Nashvillians were left in the dark, quite literally. Kids were sleeping in coats, families were bouncing between hotels, between homes of family members trying to stay warm. And so this is a result of some of the things we learned from that and trying to make some things where we can have our utility or electric utilities require transparency, real planning, and real answers to the public. It does 5 straightforward enforceable requirements for local electric systems serving 10,000 or more customers. First, it creates an annual electric reliability resilience report, be filed with the Tennessee Board of Utility Regulation, and be made public. The report must include system reliability metrics, identification of repeat outage circuits in geographic areas, restoration performance data, mutual aid usage, emergency staffing summaries, and consideration of critical facilities and vulnerable populations. Second, it would require an annual vegetation management plan that must be published publicly. The plan must explain trimming cycles by circuit type, prioritization of high-risk feeders, and contractor oversight practices. Third, it would create a 10-year grid resilience plan that would require to be published, would identify grid hardening strategies, including selective undergrounding, covering conductor, automation, and other resilience measures, and establish prioritization criteria, including mitigation strategies for repeat outage areas, and provide cost ranges and funding approaches to coordinate with roadway and infrastructure projects. I want to be clear, this section does not require the utility to build anything. It requires them to plan to show what they plan to build to the public. Fourth, it would create a major outage after action report, must be published following any declared severe weather event involving outages that exceed thresholds set by the board. This report must explain what caused the failures, what restoration challenges were encountered, and what corrective actions the utility has identified. The public, I believe, deserves real accounting of what went wrong, not a press release. Fifth, and this was really important here in Nashville, we experienced this failure. The communication standards must be maintained during declared emergencies. Utilities must provide updates on condition and restoration efforts at least once every 5 hours, explain their methodology for estimating restoration timelines, and designate a liaison for coordination with local emergency management agencies. This is basic because during a crisis, people need information, and the bill requires utilities to provide it. Mr. Chairman, at its core, the bill is about one simple principle. The people who pay for electric bills in the state have a right to know how the utility is managing reliability and what it's doing to prevent the next major outage and what happened when things go wrong. I believe this bill helps provide that information and make sure that people aren't just left in the dark. They're kept out of the dark after things happen. So we have greater planning moving forward so we don't have an issue like this again. Thank you.
Thank you for that explanation. Have any questions? I know Chairman Vaughn, you've got your hand up.
Yes, sir, Mr. Chairman, I do. And it's interesting that some of the very terms that you used in this bill, Representative Powell, were what the NES board members said that they had their after action group, not the one that is being led by Speaker Harwell and former Governor Bredesen, but the one that's being led by the law firm that they hired to do this so that they could maintain some separation between them. They were in my office this week explaining a lot of that to me. And you bring up great points. A lot of this, everybody, I think people have a lot less concern for trees now than they did prior going in. I know I'm not a fan when they're laying on my power line. I'm trying to figure out if I see the fiscal note on here that this is over $100,000 to do, so you've got to fight for that funding. My question is given the bill filing date on this and seeing what NES is doing in that regard, how do you react to that? And does that scratch your itch any, or are you thinking that it's somewhat dubious? I'm curious as your reaction to that, because it seems like they read your bill and came in and said, these are the scopes of what we're going to do. And so I'm curious, Mr. Chairman, of what our sponsors' thoughts are on how they're proposing to address this in an after-action effort.
No, I appreciate you recognizing that. And I did file this bill before that group came out. They filed that report. So there's some irony there. However, I think we need to have this in the code because, a board or a report can change. And so making sure this is in the code helps this, continue to move forward so that not just my utility, this would apply to any of these different utilities of serving over 10,000 customers, have the same plan in place. I don't want this to happen. Saw it happen in Nashville. I don't want it to happen in Memphis, Chattanooga, Knoxville, Mountain City, doesn't matter. The other thing I'll say about the fiscal note is I can't tell you the number of constituents I had and talk about $100,000 fiscal note, but the number of constituents I've had that reach out to me that said literally because of this power outage, because other things that happened, they lost thousands upon thousands of dollars. I mean, so personally, if you talk about the money that's been coming out of people's pocketbooks, and people that had to stay in hotel rooms, people that had to go buy generators. I mean, the list goes on and on. One of the things that hit me the hardest was a woman that contacted me, and she was struggling with cancer treatment, and she was having to literally go to warming shelters, and she just couldn't get warm enough even in the warming shelter. And so she was battling, cancer and treatment, and she was just freezing to death. And I told her, I said, come over to my house. I mean, you're welcome here. We saw so many different people step up, really proud of the line workers and what they did. But I think that statements change. And if they are in favor of putting out a statement or a release and having a committee that says that, then they should be comfortable with having this in the code.
Chairman Vaughn.
I appreciate your perspective. If I was the czar over this situation, I would say, because frankly, it's almost on a continuum, because Memphis, we had a large power outage about 3 years ago, and suddenly the vegetation management plan changed, and they have absolutely decimated some trees along some public right-of-ways that people thought had some type of protection. But then after they've been without lights for a week, it was interesting to see how people were excited about getting a little bit more reliability in their equation. My suggestion would be that let's look at Nashville's reports and see if we need this next year, see if that satisfies you. I know you'd like to see it for but I think it probably, I'll give you credit for authorship of the scope of services that they're doing in their report. But I think it's something that we should probably wait and see what comes out of that. But that's one person's opinion.
Representative Powell, you recognized? If not, we'll go to Chairman Lafferty.
Yeah, and I'll just say in response to that, I appreciate that. Unfortunately, my constituents are asking for relief now. They want to see plans in place now. We don't know. I mean, hopefully we're not hit with another severe weather event or another emergency like we just experienced, but you never know. I mean, just last week we had a few days ago, we had this huge wind that came through and it wasn't as bad as people predicted. But I think that it's important that we go ahead and get something in place. And look, again, this is, this is something that committee's going to study, they're going to look at. I understand that. But for me as a lawmaker, I want to make sure I hold them accountable. And I think we need this in place because we don't know when the next storm is going to hit us. So,
Chairman Lafferty?
I think my question got answered. This is not a private act. This is intended for everyone across the state. Okay. I've got, in the last couple of years in my area, we had a tornado go through. Pretty quick response. Power was back on pretty quickly. Up and down some streets in my district, I've noticed recently tree clearing that predated any snowstorms here. So it seems, I guess what I'm getting at, it seems like my district, my utility district is running things pretty tight. And I don't know, subjecting them to illnesses, faults that happened here in Nashville is something that they should be burdened with. I could better support it, I guess, if it was a private act.
You recognize?
I just say in response to that, if they are doing things right, then they should have these 5 things in there. The other thing, just to come back to my preference would be, look, if this gets to finance and dies in finance, it doesn't get funding, at least we're sending a signal that we want to see action. And then maybe we can revisit this moving forward if it doesn't get funded. But I think by moving it out of this committee and hopefully then at the subcommittee and then to the full committee, say, like, we're serious about this. And if the issue is not resolved, then hopefully we can find funding in future years.
Chairman Lafferty?
Thank you, Chairman. I'm good.
We have any other questions? Seeing none, we'll be voting on sending House Bill 2169 on the full committee as amended. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 2 ayes, 4 nays, and 3 present not voting.
Bill fails.
Thank you, Mr. Chairman. Committee.
Representative Renault has showed up. We're going to pull her back up. Item number 7, House Bill 0846. We have a motion and a second, and you're before the committee. We have a multitude of amendments.
Yes, the first untimely amendment is 15611, which rewrites the bill.
Give me that number again, please.
15611.
Okay. We get a motion on that amendment? We have a motion and a second on that amendment. Then we have another amendment, I do believe, that we're going to put on after this. Is that correct?
We can do that.
I have 2 amendments up here.
Yeah, I do want to add it, so we can add them together, or
We'll just do one at a time and then we'll put them together. Representative or Leader Camper?
Did you say this was an untimely filed amendment?
We made a motion at the beginning of the committee to accept untimely filed amendments today.
I was in another meeting presenting. Okay.
Thank you for asking, though. So we'll be voting on sending, we'll be voting on putting the untimely filed amendment of 015611 on House Bill 846. All those in favor say aye. All those opposed say no. The ayes have it. The amendment's been put on the bill. Now, would you like to put the amendment one? Let's let you tell me what amendment you'd like to put on.
the next one is 16045.
You're okay. Can we get a motion on that amendment? We have a motion and a second. Would you like to explain the amendment?
The first one or the second one?
The second one, when we're on now.
The second one just simply changes the date, effective date to March 1st, 2027.
Okay. You've heard the explanation. We'll be voting on putting amendment 16045 on House Bill 846. All those in favor say aye. All those opposed say no. The ayes have it. The amendment has been put on the bill and you're recognized on the bill as amended.
Thank you, Mr. Chairman. Committee, we've already had a fairly detailed discussion on this previously, but it has been a minute, so I want to just briefly recap it. The goal of my legislation is to ensure that there's an opt-out process for individuals who object to the biometric scan, specifically when taking a professional licensure exam. This amendment rewrites the bill to clarify its application and adds a new definition to address third-party administrators to capture the National Accrediting Organization that in the last committee that had objections that the bill didn't quite reach them. So we have added them. It also makes clear that when biometric identification is required as part of the process, individuals with a sincerely held objection, sincerely held religious or privacy objection must be provided a reasonable accommodation. Testing centers and accreditation organizations already provide accommodations today, as we talked about last time, when biometric scans cannot be completed due to either an injury or a missing limb. So if someone doesn't have a hand for whatever reason, or it's injured, they already have a process to opt that person out. So that demonstrates that the integrity of the exam does not depend on mandatory biometric collection. Also, there is no federal law that mandates biometric scans for professional licensure. In fact, opt-outs already exist in other contexts where biometrics are used. For example, you're most commonly familiar with airport facial recognition systems. They do allow opt-outs. And then I just want to make a side note that we do not require biometrics to vote, which is probably one of our most prized things that we always want to make sure people are clearly identified properly. The concern raised last committee about losing accreditation, I wanted to bring up a point that was made in the Commerce Senate Committee that in 2027, this General Assembly sponsored legislation that passed that stated that an accrediting agency or association cannot compel a public institution of higher education in Tennessee to violate state law. And so I just am pointing that out because we already have established that Tennessee law sets the standard for or against these other outside agencies that are not held to our statutes or even who we already contract with. So professional licensure is a sovereign function of the state of Tennessee. We create the boards, we issue the licenses, and we set the conditions under which Tennesseans obtain them. National associations and private vendors should not override Tennessee law, and that we should not hesitate to protect Tennesseans. So with that, I stand ready for questions and ask for your support.
Chairman Vaughn's first on the list.
Thank you, Mr. Chairman. I want to share with the committee. I appreciate the sponsor coming in and talking with me because while it is true that a national accrediting body cannot supersede Tennessee state law, they can choose not to acknowledge our licensure for reciprocity across the nation. Even though we can pass all the laws we want to and a national organization can say, that's fine, Tennessee will have its own, will be a one-of-one set with regards to licensure. That is my concern with this bill. But at the same time, the powers that be within this space have committed to working on getting this resolved. And so whenever I requested from the sponsor that she delay the enacting date, hopefully that will, given the fact that we've got laws passed, that'll provide leverage with these national groups, these national compact groups that recognize licensure from each other states. It'll give them a chance to come to the table because I do know that NCES, the party here, does provide accommodations for people with disabilities to not have to be able to qualify for their test. So it sounds like there needs to be some type of work between the two, but I think this gives us an opportunity to have productive conversations with that. And if we need to change this bill, we'll have time we'll be before the bill filing deadline next time. We can resolve a problem as opposed to us shooting in the dark with it and saying, well, we don't think it's going to affect reciprocity, or it shouldn't, but hopefully we'll get it resolved and we'll get it to where they don't have to put these biometric scans on there. So that's where it comes from. And I'd like to say, I heard I'm about to get in trouble. I'll leave that one alone.
Thank you. I think that was pretty much just a statement of the history of where we are. See any other questions? Seeing none, are there any other questions? Seeing none, we'll be voting on sending House Bill 846 on the full committee as amended. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 2 nays.
House Bill 846 on the full commerce. Thank you for your hard work.
Thank you, Chairman Committee.
I think we're caught back up now. We are back in order. We are on item number 14 by House Bill 1940. We have a motion and a second. Representative Johnson, you are recognized.
Thank you, Mr. Chairman. House Bill 1940 is a bill desperately needed. I know definitely in Knoxville, but I think around the rest of the state when people are having such difficulty finding a place, finding housing, finding a place to rent. This bill makes eviction records confidential and shielded from public viewing after July 2026 if the case was dismissed in court and if it has been more than 3 years since the eviction happened. Several landlords utilize online screening companies to make decisions on who to accept as tenants, but these screening tools will often automatically reject applicants if they've had a prior eviction, even if the eviction was dismissed and they didn't follow through with it, or if it's been years since the eviction happened. There's several nonprofit groups in Knoxville who study, why are folks not able to get housing and what is keeping people from housing. And this was one of the main things that they found were these eviction records. So these screening tools gather information from public eviction records. So sealing records of evictions from tenants that are not at risk will protect them from being rejected and therefore not having a place to live. Additionally, these tools are usually not checked by an actual person for denial or approval. 2/3 of landlords receiving tenant screenings contained AI-generated information and recommendations. Didn't come from people reviewing them, but being reviewed by AI, and that's 2/3 of them. Tenant screening companies profit from landlords using their services as a quick fix to see who would be a good tenant, but this evaluation is based in information that may not be currently relevant. Only 5.5% of eviction filings actually led to a formal eviction, meaning that when these complaints are filed, they stay on someone's record and it follows them regardless of whether or not they were actually evicted. Eviction stats are rising and these screening companies are benefiting from flagging tenants as bad because of this, because of something that could be years old and no longer relevant. These records are often an unreliable proxy for whether a tenant will be capable of paying their rent. Currently, current income is a far more reliable representation of their ability to pay and be good renters. The American Bar Association has called for sealing of records at the point of filing because of their negative impact and lack of relevance in the current time. Many states have passed laws like this in bipartisan efforts, including Idaho, North Dakota, Arizona, and Indiana, and many others, in order to protect renters and provide more accessible housing. I just spoke to someone from Knoxville in the nursing home business, and when people leave their home, they have trouble housing folks sometimes because they have to release them to a place. But if they are barred from that, usually because of these things, it becomes a huge problem with placing folks leaving those nursing homes. So I would ask that you pass House Bill 1940.
You've heard the description by the representative. Do we have anyone have a question? I do have someone on the list, Representative Johnson. Are they here with you to testify?
I do
Mr. John
not.
Hickman? Would you like to? He is in opposition, I do believe is what I have down. So without objection, we're going to be going out of session. You have 3 minutes to make an opening statement. Then the committee may ask questions of you.
Yes, sir.
Please identify yourself. You're welcome. You're recognized.
Yes, sir. My name is John Hickman. I'm an affordable housing provider, have been in the business for 20 years. And I'm opposed to this bill for 2 reasons. One is I can't tell you how many times that I've had someone tell me right to my face and sign on the dotted line in an application, oh, no, I don't have any evictions. And then come to find out in processing it manually and looking things up, yes, they actually do. And since I'm in charge of a sometimes a multi-$100,000 asset, both for myself and sometimes for other people,
I take that responsibility seriously. So I don't want to do a bad job for myself and my clients. The other concern I have about this is if in this situation, and this is a very specific set of circumstances, an eviction can be obfuscated or hidden from public investigation. I'm worried about, okay, what about the next bill that hides certain parts of discoverability of evictions? Or what about the next piece of legislation? I guess you could say I'm worried about legislative creep and regulatory creep on something like this, and eventually making my job harder in the future, and as well as putting future housing providers in a situation where their bottom line and a whole chain of people are affected. That's about all I got.
Thank you for that. Thank you for coming over. Any questions for the witness? Leader Camper, we'll go with you first and then.
Thank you, Mr. Chairman. Thank you for your testimony. Have you seen in your, I think you said 30 years or so?
Oh, no, just 20.
Oh, 20. I got that wrong. In your 20 years that there may have been people who maybe experienced a tough time and they, probably
absolutely
were evicted and went on to be more gainfully employed and back, where they can, rent a home. Maybe 3 years have passed. Have you seen where it would be helpful for people like that who was in a terrible situation and they're trying to get their feet back on the ground, and so now they're able to rent from you or any of the people that you may represent, and that eviction is not holding them back from trying to get future housing?
Mr. Hickman?
Yes, Mr. Chairman. I absolutely have seen that. In fact, I've worked with people in the past who had a one-off tragic event that derailed their finances and their life, and they were getting back on their feet. And I'm happy to say that I was part of helping them get back on their feet and have a home. I don't really use AI in my business. I'm still kind of old school. I guess you could say I'm a Luddite, but I don't just take what a computer spits out, offhand. I like to look and see what the person is doing too. And sometimes that has hurt me, but sometimes it's helped, and I've been able to help, people get that, get a home. So, yeah.
Okay. Leader Camper?
Thank you, Mr. Chairman. Do you think 3 years is a reasonable time? Should this bill pass and people are able to be shielded? You think 3 years is reasonable? Or what you think maybe 4 or something like that? What do you think would be reasonable?
Mr. Hickman?
I think thank you. I think something more reasonable would be something in line of bankruptcy laws, like maybe 7 years or something like that.
Okay.
I mean, that's just my thought. That's just my thought. Yes, ma'am.
Chairman Clements?
All right, thanks.
Thank you, Mr. Chairman. Yeah, I guess what I'm hearing is your concern that you've had experiences where people misrepresented their history to you. Is that correct?
Yes, sir.
And so this doesn't limit or do anything to, I guess, address that. I mean, that's not being talked about by this. This is just looking at a reasonable period of time to where people, they go through rough patches and then they get back on their feet, and they shouldn't have that held against them. And as I understand it, some of these systems don't even allow for the landlords to review it because the system boots them out automatically. So they're not even on the list of people for someone like you to consider all the other circumstances, and I've seen this a lot with single mothers who've gotten divorced, and they're kind of battling through some sort of judicial, and they're having a hard time making ends meet, and they've gotten out of their home and they're raising their children and they're going through a rough patch, and they might get evicted during that pendency of a divorce or something like that. And then, they get back on their feet. And I would hate for a single mother or somebody in that type of situation to have an eviction for 5 years before prevent them from being able to put a roof over their kid's head. And so, and I'd certainly hate to have someone, who had an action brought against them that was dismissed, held against them. So, I mean, does your concern go further than people who've lied to you in the past, which is inappropriate, but I don't know that this is going to solve that issue.
Mr. Hickman, you recognize.
Thank you, sir. Appreciate it. Don't know the protocol. Sorry.
You're fine.
I guess my main concern would be not so much the time frame. It'd be understanding whether the circumstances might be replicated, whether it was a one-time tragic event like a divorce or a health issue or something like that, or if it was something ongoing like a pattern of behavior. That's the main thing I'd be looking for.
Well,
Chairman Clemens?
yeah, thank you, Mr. Chairman. And I certainly appreciate that. And that's always going to be a challenge. And if it's a pattern of behavior, then you're certainly going to have evictions within 3 years, I would assume. But I don't think, that one eviction during a rough patch necessarily indicates a propensity to fail to pay rent or, for everybody. So I think we've got to, stepping back at this, looking at how we form public policy, we've got to look at the cost and benefits, and so I think this potentially benefits a lot more people, but I appreciate your opinion and your perspective on this.
Thank you. Any other questions for the witness? Representative Lafferty?
You mentioned in your opening statements, I guess, that you do help out other folks. You don't just manage properties for yourself. Did I hear that?
You're recognized.
Yes, I volunteer for a group called the Real Estate Investors of Nashville. So I'm on the board of that. So I help affordable housing providers in the city of Nashville and the surrounding areas invest ethically and responsibly and hopefully profitably to stay in business, but not in a scalping kind of way. But that's my main nonprofit kind of way, in
Chairman
addition
Lafferty?
to customers.
Okay. I just, I thought, I was thinking of, a lot of times we are looking at the people affected by this bill as being just the tenants, but the other people that are affected by the bill are also the mom and pop operator that maybe only have one or two rental properties, and that's their life savings or their income in retirement. And to your words a second ago about 3 years being a pretty short period of time, people talk to you. People lie. People lie all the time, and they aren't forthcoming. Your comments about 3 years not really being enough of a time period, I think you hit that nail on the head. But I just wanted to share my thoughts with the committee. This isn't just about the person that's looking to get the property. We've also got another side to that coin, and that is that maybe that's grandma's house that she left to the kids, and that's their greatest asset, and it gets them another $600, $1,000 a month. Well, if they end up doing business with somebody that's protected by this 3 years and they were lied to, then they may be months trying to get them out, plus whatever damages might be going on. I mean, it's not just the, say, $1,000 a month that's lost in the income. It's also the thousands, sometimes tens of thousands of dollars that can be done in damage to the property. So there's two sides to the coin. We're looking at it, it seems, from one point of view. I wanted to bring the other point of view as well. But thank you for being here.
Thank you. I don't have any other person on my list to ask a question. Thank you, Mr. Hickman, for being here. Without objection, we're going to go back into session.
Can I make a statement for?
Chairman,
I
I'll
should
come
be
to you.
allowed to make a statement.
I'll come to you first. Let
Okay.
you make your statement, then I'm going to go to Chairman Bricken.
Thank you so much. And the 3 years, that was based on data that shows when it's older than 3 years, and if you go ahead and rent to that person, it's usually good. And so the number was come through years. That 3-year number came from research and data that demonstrates this has been successful most of the time. When people lie, we're going to pass laws and people are going to lie anyway. But the reality is we've got to deal with what most of the people have. And we do need to protect landlord. I rented once and they were perfect on paper and I lost big. So I understand that. However, when this is preventing so many people and this bill goes back 3 years, and in addition to that, it removes any that were evictions, complaints that were not followed through with. And I think that's critically important. So thank you.
Thank you for that. Chairman Bricken? Question been called on the bill. Any objections? Seeing none, we'll be voting on sending House Bill 1940 on to full committee. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 2 ayes, 5 nays, and 1 present not voting.
Representative Johnson, the bill fails.
Thank you, Mr. Chairman. and
Thank you for
committee.
being. Next on our list is item number 15, House Bill 2456. We have a motion and a second. Representative Pearson, you are recognized before the committee.
Thank you, Mr. Chairman, and thank you, committee. Before you is HB 2456, Data Center Reporting Requirements legislation. As you all know, data centers are a significant part of what is happening in our country right now. There's a significant push, even at the national level, to potentially put a moratorium, but there's a recognition all across our state and across the country that really what we need first is more information. Right now, there are roughly 61 data centers in the state of Tennessee. This legislation would only impact roughly 10 of those, and this is only actually looking ahead to just provide information to the Department of Revenue. So we would know more about the data centers, potentially the largest ones that have and will use over 20 megawatts of power. It would have their address, name, mailing address, the likely data center's power capacity, the name of the electric utility and water utility who would be providing services to the data center, and the name of each supplier of fuel if they'll be using fossil fuels. Right now in our country, with so many conversations happening about data centers, I think it's just really important that we have access to information about who are operating in our state. And so they would just register with the Tennessee Department of Revenue. Again, it isn't going to be overly cumbersome. The address, contact information, approximate power capacity, electric and water utilities, and then the backup fuel suppliers if they'll be using that. Many places within our state do provide tax breaks and incentives for these companies to be here. And so we deserve to have transparency and access to the information. This also helps us to think about infrastructure planning, consequences that might exist for our grid capacity, as well as for the use of our water and our utilities, particularly when I think about back home. We got an aquifer underneath the Memphis Sand Aquifer in West Tennessee that provides us fresh drinking water. And so knowing how much of that is going to be used is really important. The fiscal note is not significant. It's even written inside of here that the Department of Revenue can develop a registration process, communicate with energy suppliers and utilities, and compile and publish to its website the data received from such suppliers and utilities within existing resources without a significant increase in state expenditures. Any increase in state expenditures estimated to not be significant. Most people in our community just want more transparency. So that's what this legislation seeks to do. Thank you so much.
First on the list, Chairman Lafferty.
Call question, Mr. Chairman.
Question been called. Any objections? Seeing none, we'll be voting on sending House Bill 2456 on the floor. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 2 ayes, 5 nays, and 1 present not voting.
House Bill 2456 fails.
Thank you, Chairman and committee.
Next on our list, item number 16, House Bill 2132. Chairman Bricken, got a motion? And a second. We got a motion and a second. You're recognized.
Thank you, Mr. Chairman. This is certainly an important bill to me because it comes from a constituent of mine, a grandfather who lost his 8-year-old son who was sucked down by a storm drain in Rutherford County almost 2 years ago. And it certainly, we should all as citizens and parents of kids and everything else be aware of the force of water when it goes down a culvert. And because we lose across the nation probably 5 to 10 citizens because of being sucked down a culvert. So this bill certainly came from the grandfather and asked to be carried. But structurally, the bill, I found out, kind of has some problems with kind of the structure of it. But I have a commitment from the Tennessee Society of Engineers and from TDEC to come up during the summer before next year with some kind of umbrella guidelines and codes that all, not only state agencies, cities, and county can operate to say when they have a storm drain or a culvert, they identify the safety concerns and put the proper guardrails, fencing, or whatever in those environments. So I'm going to ask the committee to vote this to summer studies and let's get the work to correct the kind of the definitions so we can get this laid out to our citizens. So there you go.
Is that in the form of a motion there, Chairman Bricken?
Yes, it would be.
So House Bill 21, okay, hold on. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman. I make a motion that we send this to summer study.
Okay. Chairman Boyd makes a motion. We got a motion and a second to send this bill to summer study. All those in favor of sending House Bill 2132 to summer study, say aye. All those opposed, say no. The ayes have it. Your bill has been sent to summer study, Chairman Bricken.
Thank you.
That
very
brings
much,
us to item number 17, House Bill 1926. We have a motion and a second. Your property before the committee, recognized.
Thank you, Mr. Chairman and committee members. This bill certainly is I'm going to call it a little bit of bicentennial celebration bill. It expands the selling days by our individual firework permitted licensees or whatever around the state to sell fireworks during this year only, on Memorial Day weekend, and expand the selling season from June 19th, June 10th to July 10th. So it covers the June 19th holiday. But anyway, it's a way to hopefully ring in this very special year. And with that, I renew my motion.
He renews his motion. House Bill 1926, Representative Boyd, you're recognized.
Thank you, Mr. Chairman. I'd like to make a motion to send this wonderful semi-quincentennial bill. No, I'd like to call the question on it. I'm sorry, I got confused. We're
Thank you.
question on this semi-quincentennial bill.
Question's been called on sending House Bill 1926 on the full. So we'll be voting on sending House Bill 1926 on the full. All those in favor vote yes. All those opposed, vote no. Mr. Clerk, take the vote. Mr. Clerk, give us a little juice down there for the clerk. Thank you.
Mr. Chairman, you have 6 ayes and 2 nays.
House Bill 1926 on the full committee. Next on our list is Chairman Vaughn, but he's not here, so we'll go to item number 19, House Bill 1985 by me. You are recognized.
All right. So I wasn't fair for him. All right, Chairman Grills, you got House Bill 1985. I think it has 3 amendments. Which one would you like to adopt?
We got a motion and a second.
Do we have a motion second? Motion. Okay.
Thank you.
Thank you. We have which amendment would you like to?
015754.
That is correct. We have a motion and second on the amendment.
Motion.
Second.
All in favor of putting the amendment on the bill?
Aye.
Say aye. Aye. The amendment is there on the bill. Is the amended bill, would you like to describe it?
Yeah, thank you, Mr. Chairman. This bill allows for licensing rules for IT managed services providers, allowing them to install and service IP cameras as part of the normal IT work without being regulated as security contractors. We have worked with the security contractors and alarm contractors, and this is the compromise we've come to. So with that, I stand ready for questions.
Any questions? I hear a question on the bill. No objections. If the clerk would open up the board for vote. Has everyone voted? Would you announce the vote?
Mr. Chairman, you have 6 ayes, 0 nays, and 2 present not voting.
The amended bill passes. I'm not sure where it goes.
Full.
Done.
Without objection, we'll have a 1-minute recess. Yeah. We are back in session.
I do appreciate every committee member here. Thank you.
Hey, we're back in session now. We are on item number 18, House Bill 2381. While Chairman Vaughn's catching his breath. You good?
Good.
And recognized. We have a motion and a second. You're properly before the committee. I do have an amendment. I believe you've got one too.
I hope they match, Mr. Chairman, 015472. Uh-oh,
Let's go to Bill 2381.
that is 2381.
How about Amendment 012964?
Yeah, that's the one I've got. Yes, sir.
Hold on just a second. We're going to make sure legal and what is that amendment number one more time, Chairman Vaughn?
It is 012964. And I had previously had one that was 015472.
We do have both of those.
Okay, there you go.
You want to go with 01?
015472 would be my preferred one.
015472. We
Yes,
have
sir.
that one.
Yes, sir.
We have a motion on that amendment. We have a motion and a second on that amendment. You're recognized on the amendment. Would you like to explain it or would you like to put the amendment on the bill?
If we could put the amendment on the bill, sir.
We'll be voting on putting House Amendment 015472. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. The amendment's been put on the bill and you're recognized on the bill as amended.
Thank you, Mr. Chairman. And the reason it's important we got the right bill on amendment on there was because it was due. We amended some things in dealing with stakeholder groups and we wanted to make sure that we abided by our agreements with it. This bill deals with a few things. What we have determined whenever we started last year with allowing customers to install their infrastructure, we started seeing some things pop up that were either, I guess one of the few ways, one way it could be looked at was people were finding ways to execute hostility towards the allowance of contractor or customer installed utilities. And so what this does is this addresses three areas that are some of the problems. One is that the utility, if it requires people to buy equipment or parts from them, then they can't mark it up. So we saw that people were doing their utility store. They'd open the utility store where they were charging people who were wanting to install their own system premiums for buying the materials. The other is to you can't require a customer to both install the electric system. You can't require them to install the electric system and the street lights if they don't want to. You can't make them do a package deal. And part of that comes by we have different municipalities charge people differently and have different ownership programs for street lights. And when you bundle them together, then sometimes that effectively diminishes the ability of someone to install their own utilities. And then the last is we're capping design and inspection fees at 10% of construction cost.
You've heard the explanation and description by Chairman Vaughn. Leader Cochran,
Question on the bill.
question's been called on the bill. Any objection? Seeing none, we'll be voting on sending House Bill 2381 to full committee. All those in favor vote yes. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 0 nays.
The ayes have it. 2381 on to full commerce. And with that, ladies and gentlemen, that concludes our calendar. And for the year, we should be able to not have to worry about coming back. But if we do, we're going to close Subject, call to the chair after Chairman Lafferty is recognized.
I just wanted to say, sir, for picking up on the fly and carrying us the rest of the way, you did a fantastic job this year.
Well, thank you. Thank you. Chairman Vaughn, if you want to brag on me, I'll let you do that too.
Yeah, I was going to say something about you, Chairman Grills, and that is there's more to being a chairman than what you see in this room. And he got immersed in subject matter that he didn't have much practical experience in dealing with. And he took to it like a duck to water. And I think that's probably the most impressive thing I've seen. You've ran a committee room before, but understanding what we were dealing with, you put in the extra work that it took to understand it, and we certainly appreciate that.
Well, thank you very much. You've been very good to me. And anytime I had a question, he'd always answer the phone. And I'm happy my wife was here to hear all that nice stuff they said about me. Without objection, we'll adjourn. Subject, call to the chair.